So this just happened. In an 8-1 emergency decision, the Supreme Court issued an order that is already sending shockwaves through the Second Amendment debate, and almost nobody saw it coming. Not because the issue was minor, not because the legal questions were simple, but because when 8 justices agree on anything touching gun policy in today's political climate, that alone is a headline. This wasn't a routine denial buried in the orders list. This wasn't one of those procedural footnotes that legal insiders notice and everyone else ignores. This was an emergency application, meaning one side told the court something urgent and irreversible was happening right now, and by an 8-1 vote, the court responded in a way that immediately disrupts how Second Amendment policy is being fought across the country. Before we break this down, understand something important. Emergency orders are not normal appeals. They're fast, they're high stakes, they often happen with limited briefing, and they signal how at least a majority of the court views the immediate constitutional balance. Now, here's what makes this extraordinary. The vote wasn't 5-4. It wasn't ideological. It wasn't conservative versus liberal. It was 8-1. And the lone dissenter? Justice Clarence Thomas, the court's most consistent and forceful defender of an expansive Second Amendment interpretation. That alignment alone tells us this decision is not about whether gun rights exist. It's about something deeper, something structural, something constitutional that even strong Second Amendment supporters were unwilling to override on an emergency basis. So what triggered this? At the center of this case is a growing national strategy that some states have adopted over the past decade, refusing to cooperate with federal gun enforcement policies they believe violate the Second Amendment. These laws, often referred to as Second Amendment preservation or gun sanctuary frameworks, don't technically nullify federal law. Instead, they rely on what's known as the anti-commandeering doctrine. That principle, recognized by the Supreme Court in cases like Prince v. United States, holds that the federal government cannot force state officials to implement or enforce federal regulatory programs. In other words, the federal government can pass a law, but it cannot compel state officers to enforce it. For years, that doctrine has been used in multiple policy areas: immigration, marijuana enforcement, healthcare exchanges. Often with the court's blessing, states can decline participation. But here's where the collision begins. Some states went further. Instead of merely declining to cooperate, they created penalties for state officials who assist federal gun enforcement. In certain cases, those laws allowed private citizens to sue local officials for cooperating with federal agencies. The goal wasn't just neutrality, it was active deterrence. And that is where the constitutional tension sharpened. The emergency case before the court involved one of these broader frameworks. Lower federal courts had blocked it, arguing that while states are not required to enforce federal law, they cannot actively obstruct or punish cooperation with federal enforcement. The state asked the Supreme Court for emergency relief, essentially asking the justices to lift the lower court's block while the full case continues. The Supreme Court refused by an 8-1 vote. That refusal keeps the lower court's injunction in place, meaning the state law remains blocked for now. Now, pause for a moment, because here's the key point. The court did not issue a full merits ruling. This is not a final decision on constitutionality, but emergency votes matter. They signal how the majority currently views the balance of harm and legal clarity. And what this vote suggests is that a broad coalition of justices across ideological lines is not comfortable allowing states to implement punitive non-cooperation frameworks against federal gun enforcement while litigation is pending. That's significant. It suggests that while the court has expanded individual Second Amendment protections in recent years, especially in New York State Rifle and Pistol Association v. Bruin, it is not prepared, at least at this stage, to greenlight aggressive state-level resistance mechanisms that risk direct structural confrontation with federal authority. This is where the constitutional architecture comes into focus. On one side, you have the Supremacy Clause of Article 6. It establishes that federal law is the supreme law of the land, binding on state judges and overriding conflicting state statutes. On the other side, you have anti-commandeering, the principle that states cannot be forced to administer federal programs. Both doctrines are firmly embedded in constitutional jurisprudence. The unresolved question is where the line exists between passive non-cooperation and active obstruction. Can a state say we won't help?
Almost certainly, yes. Can a state say we will punish anyone who does help? That's the frontier, and 8 justices just signaled serious concern about crossing it, at least on an emergency basis. The broader implications ripple outward immediately. Other states considering similar legislation are now watching closely. Legislative sessions across multiple regions included draft proposals built on the assumption that anti-commandeering offered strong constitutional protection. This emergency denial complicates that calculation. Lawmakers now face a warning. Even if you pass it, expect immediate federal litigation, expect injunctions, expect years of courtroom battles before implementation. And politically, that changes strategy. Instead of relying on state-level resistance mechanisms, gun rights advocates may increasingly return to direct constitutional challenges against specific federal regulations. That's slower, it's more expensive, but it may be more durable. Justice Thomas's lone dissent is also worth examining, though we don't yet have a full written explanation. Historically, Thomas has been the justice most willing to aggressively defend expansive Second Amendment readings. His solo vote here suggests he believes the emergency relief should have been granted, possibly viewing the state's law as a legitimate exercise of sovereignty under anti-commandeering principles. But the fact that Justices Alito, Gorsuch, Kavanaugh, and Barrett joined the majority in denying relief indicates something critical. Even strong Second Amendment jurisprudence does not automatically translate into approval of every state strategy used in its defense. This decision does not weaken the Second Amendment directly, but it reshapes the battlefield. And it forces a bigger question into the open. Is the future of gun policy going to be decided primarily through national constitutional litigation or through decentralized state resistance? For now, the Supreme Court just signaled that aggressive structural resistance may not get a green light without a full merits fight. And that fight is far from over. Now let's go deeper, because what's unfolding here is bigger than one state law, bigger than one emergency order, and arguably bigger than gun policy itself. At its core, this 8-1 decision exposes a constitutional tension that has been quietly building for decades. On one side is the Supremacy Clause, on the other is the anti-commandeering doctrine. Both are legitimate, both are established, and both are powerful. The Supremacy Clause, embedded in Article 6 of the Constitution, declares that federal law is the supreme law of the land. When Congress passes a constitutional statute, states cannot override it. State judges must apply it. Conflicting state laws are preempted. Simple in theory, but anti-commandeering complicates that simplicity. The anti-commandeering principle was strongly reinforced in cases like Prince versus United States, where the court held that the federal government cannot require state officers to conduct background checks under the Brady Act. The reasoning was structural. States are sovereign entities within the federal system. Congress cannot conscript them into administering federal programs. This doctrine was also affirmed in Murphy v. NCCA, where the court struck down a federal law that effectively dictated what state legislatures could and could not authorize regarding sports gambling. So the pattern seemed clear. States cannot block federal law outright, but they can decline to assist in enforcing it. That distinction between non-cooperation and obstruction is everything, because in recent years, some state-level Second Amendment preservation frameworks crossed from passive refusal into active deterrence. Instead of simply saying, our officers won't help enforce federal gun restrictions, certain statutes added enforcement mechanisms against cooperation itself. Some imposed civil penalties, some authorized lawsuits, some created financial liability for officials who assist federal agents. And this is where the constitutional alarm bells start ringing. From a structural standpoint, the concern is that if states can penalize cooperation with federal gun enforcement, they are no longer merely declining participation, they are interfering with the operation of federal authority. That distinction likely drove the 8-1 outcome. Remember, this was not a full merits ruling, it was an emergency application. The question before the court wasn't whether the law ultimately survives. The question was whether it should go into effect immediately while litigation continues. 8 justices said no. That signals concern about immediate constitutional harm, potentially to federal supremacy or operational capacity. And here's why this matters beyond gun policy. If a state can punish its own officials for assisting federal gun enforcement, what stops another state from punishing cooperation?
Immigration enforcement? Or federal environmental enforcement? Or federal tax investigations? Or federal drug enforcement? The structural implications extend far beyond the Second Amendment. This is about the architecture of federalism. The court has long allowed states to opt out of federal schemes, but it has been wary of allowing states to actively obstruct them. That line is thin, but critical. Consider immigration sanctuary jurisdictions. Courts have generally upheld their ability to decline cooperation with federal immigration detainers, but those jurisdictions typically do not impose penalties on local officials who choose to cooperate independently. They set policy limits. They don't criminalize cooperation. That nuance may be central to why this emergency request failed. The Supreme Court may be signaling refusal is allowed, retaliation is not. Now let's talk about timing. This emergency order arrives at a moment when federal gun regulation remains politically volatile. Regulatory agencies have implemented rules on firearm components, dealer definitions, and other technical aspects of gun commerce. Litigation challenging those rules is ongoing nationwide. In that environment, state-level preservation laws were viewed by some advocates as a parallel defensive shield, a way to reduce enforcement impact even if federal courts upheld certain regulations. But the 8-1 emergency denial complicates that shield. States now know that aggressive preservation statutes may be frozen before they ever take effect. And federal district courts, which issue preliminary injunctions, are likely to feel reinforced by this signal from the Supreme Court. Emergency denials don't create formal precedent, they create momentum. Lower courts read them carefully. They see where the majority stands, at least provisionally. Justice Clarence Thomas standing alone here is notable, but not entirely surprising. His jurisprudence often emphasizes historical grounding and structural limitations on federal power. He may view anti-commandeering as a robust shield for state autonomy, even when exercised aggressively. But the rest of the court, including strong Second Amendment supporters, appears cautious. That caution tells us something important. The justices may be drawing a boundary between expanding individual gun rights, as seen in New York State Rifle and Pistol Association v. Bruin, and destabilizing federal enforcement architecture. Those are different questions. One deals with individual constitutional rights.
The other deals with intergovernmental power balance, and the court may be far more comfortable policing individual rights than refereeing structural showdowns between states and the federal government. There's also a strategic dimension. Emergency relief requires showing irreparable harm and a strong likelihood of success on the merits. If the court believed the constitutional question is unresolved or complex, denying emergency relief preserves stability while allowing full briefing and argument later. In other words, slow down. And slowing down changes politics, because legislative enthusiasm often depends on momentum. If states know their preservation statutes will sit under injunction for years before implementation, political incentives shift. Litigation becomes the central battleground again, and litigation is national, which means the future of Second Amendment policy becomes increasingly dependent on the composition and philosophy of the federal judiciary, not state resistance. That centralization may frustrate advocates who prefer decentralized safeguards, but it also reduces the risk of 50 different enforcement realities clashing simultaneously. From the court's perspective, uniformity matters, stability matters, institutional legitimacy matters. An 8-to-1 emergency denial suggests the majority was unwilling to risk rapid structural fragmentation while the constitutional lines are still being defined. So what happens next? The case returns to lower courts for full litigation. There will be factual development. There will be detailed constitutional arguments. Eventually, the issue could return to the Supreme Court on full review. And that's where the real doctrinal line may finally be drawn. But for now, this emergency order has done something immediate. It has disrupted the assumption that anti-commandeering provides a blank check for state-level Second Amendment preservation strategies. And that disruption reshapes the policy battlefield nationwide. So where does this leave us? An 8-to-1 Supreme Court emergency decision, a blocked state-level Second Amendment preservation framework, a lone dissent from Justice Thomas, and a constitutional line that suddenly looks far less certain than many expected. Now we zoom out, because this isn't just about whether one state can penalize cooperation with federal gun enforcement. This is about the future strategy of the Second Amendment movement and the structural limits
of federalism in modern America. For the past several years, the expansion of individual gun rights has largely flowed through the courts. The landmark decision in New York State Rifle and Pistol Association versus Bruin reshaped the analytical framework for evaluating gun regulations. The court rejected interest balancing tests and replaced them with a historical tradition standard. That was transformative. But Bruin addressed individual rights, not state resistance. This emergency order addresses something different, whether states can use their sovereignty not just to abstain from federal programs, but to actively deter participation in them. And that's a much more volatile question, because if the court ultimately draws a firm line limiting punitive non-cooperation laws, it means the primary battleground for gun policy returns to federal courts and federal elections. No structural shortcuts, no state-level insulation against enforcement. Instead, every major regulation must be challenged directly under the Second Amendment. That's expensive, that's time-consuming, and that favors well-funded, nationally coordinated litigation campaigns. It also centralizes power. Think about what aggressive preservation laws were attempting to do. They were trying to create friction, to make federal enforcement practically difficult, even if legally authorized. If state databases, state labs, state personnel, and state funding cannot be used, federal agencies must operate independently. In theory, that limits enforcement capacity. But the Supreme Court's 8-to-1 signal suggests when friction turns into punishment, the constitutional tolerance narrows. The court appears wary of allowing states to transform anti-commandeering into a tool of obstruction. That distinction may define the next decade. Let's talk about what this means politically.
State legislatures across the country were watching closely. Some had draft proposals ready, others were strengthening existing statutes. Advocacy groups were promoting preservation frameworks as a parallel defensive strategy alongside litigation. Now, those legislatures face a recalibration moment. Passing a law that immediately triggers federal lawsuits and likely injunctions may not produce immediate policy impact. It may instead generate prolonged courtroom battles. And for politicians, symbolic victories are different from operational ones. The chilling effect is real. When the Supreme Court sends an 8-to-1 message, especially on emergency review, it changes risk assessments. Lawmakers begin asking not just can we pass this, but will it survive long enough to matter? And that question is now harder to answer confidently. There's another layer here: institutional credibility. The Supreme Court has faced intense scrutiny in recent years, especially in high-profile constitutional disputes. An 8-to-1 vote across ideological lines projects something powerful: consensus. Even in one of the most politically charged areas of American law, 8 justices aligned. That alignment may not last when the full merits case arrives, but for now, it sends a message of institutional steadiness rather than partisan fracture. And that matters for how lower courts respond. District courts and appellate panels read signals carefully. An 8-to-1 emergency denial suggests the majority of the Supreme Court is cautious about expansive structural experimentation at the state level. So lower courts may feel emboldened to maintain injunctions against similar laws while litigation unfolds. That creates a reinforcing cycle. Now consider Justice Thomas's dissent. Though we do not yet have a full opinion, his record suggests he likely sees the anti-commandeering doctrine as robust and deeply rooted in constitutional structure. He has repeatedly emphasized original meaning and historical understanding of federalism limits. His lone vote may foreshadow a future merits argument, one that insists states retain broad autonomy to structure internal governance, even as that indirectly limits federal enforcement efficiency. And history tells us something important. Solo dissents sometimes plant seeds, but seeds take time. For now, the majority has drawn a provisional boundary. So, what are the possible long-term scenarios? First possibility: the court eventually grants full review and clarifies that states may refuse cooperation but may not penalize cooperation. That would lock in a narrow anti-commandeering shield, one protective of neutrality but hostile to retaliation. Second possibility: the court refines the doctrine more aggressively, perhaps distinguishing between civil penalties and criminal sanctions, or between internal administrative discipline and private lawsuits. Third possibility: the court ultimately affirms broader state autonomy, vindicating Justice Thomas's view, but only after full briefing, oral argument, and extensive doctrinal refinement. Each path reshapes strategy. If punitive preservation,
Frameworks are limited. Advocacy energy shifts decisively toward direct constitutional litigation under the Bruin Standard. If broader autonomy is recognized, states may experiment further, but with clearer boundaries. And if the court narrows anti-commandeering in this context, that would have ripple effects far beyond guns. Because once the court defines the limits of state resistance tools, those limits apply everywhere: immigration, environmental regulation, public health mandates, tax enforcement. Federalism lines are rarely issue-specific, they become structural precedents. That's why this emergency decision feels larger than it appears. It's not rewriting the Second Amendment. It's testing the outer edges of federal-state tension in the modern era. And perhaps most importantly, it reminds us that constitutional expansion in one area does not automatically justify structural confrontation in another.
The Supreme Court has shown willingness to strengthen individual gun rights, but it has also shown caution about destabilizing federal enforcement systems. Balancing those instincts will define the next phase of Second Amendment policy. So here's the big question moving forward. Will the future of gun rights be decided primarily through courtroom doctrine and historical analysis, or will states continue pushing the boundaries of sovereignty to create enforcement friction? The 8-to-1 emergency order doesn't end that debate, but it disrupts assumptions, it slows momentum, and it signals that even in one of the most polarized areas of American law, there are structural guardrails the court is not eager to dismantle overnight. This case is not finished. The litigation continues. The constitutional questions remain open. But the battlefield just shifted, and everyone involved now knows it. Stay informed.